Hey everyone, welcome to Legal Bytes. I'm Alita, I'm a lawyer, and on this channel we explain the law one bite at a time. Today we're talking about trusts, both generally and with a particular focus on the Revocable Trust, also commonly known as the Revocable Living Trust. What is it for, and what happens when you create a trust? If you're an American watching this, it's crucial for you to understand what a trust is so you can make good decisions in your estate planning, partly just to decide whether or not you actually need one in the first place. And if you haven't done any thinking about your estate planning, no matter what your age, now is a good time to start. So stick around for the whole video so you can understand all of the basics about trusts, in as efficient and entertaining a way as possible, of course. And it looks like maybe partially joined by Holmes here. Coming up on Legal Bytes. Okay, nobody. So if you've been watching our videos for a while now, this one will likely seem a little different from what you're used to, since we normally cover topics that somehow intersect with pop culture or current events. But because this is first and foremost a legal education channel, I've also been wanting to include for a while now videos that are more quote-unquote evergreen, meaning that they'll be relevant for a long time, and which can serve as a reference for people looking for this kind of information. What are you doing? Hey! No! You're not supposed to be up there. Okay, sorry about that. Rest assured, this is not some new direction for the channel. Instead, think of it as we're adding to the channel's portfolio videos that are maybe a little more instructional, which are pretty likely to be relevant to most people anyway. And otherwise, if you found our channel through this video, consider checking out the rest of our videos after this one to see what other fun topics we cover with the law, like movies, video games, tech, social media, elections. I guess that last one isn't exactly fun, but it is important and it's good to know about. Anyway, let's get on with it. A trust can be a little tricky to understand since it's primarily conceptual and doesn't really have any physical presence other than the trust document that governs it. But if you can understand the concept of a corporation, you can also understand the concept of a trust. Basically, a trust is a creative way of holding ownership of your assets. By assets, I mean your bank accounts, real estate, personal property, that kind of thing. There are a lot of reasons why people will want to put their assets into a trust, but the most common reason you'll find is to avoid probate when the owner of the assets passes away. Probate, in its most basic definition, is the process of going through a deceased person's assets and determining where they're supposed to go, which creditors need to be paid, what taxes are due from the decedent, what is supposed to go to the heirs. It's all done through the probate court, which is sometimes called other names like orphans court, surrogates court, or a chancery court. It's not a total disaster if someone's assets have to go through probate in order to be distributed to the heirs. But generally speaking, people who want to avoid it typically do because it usually can be characterized in three ways. First, it's long. It can take from months to even years before the estate gets totally administered. Second, it can be expensive, partly because of how long it can take. And third, it's all public record. If you don't want the world to find out what kind of assets you have or what kind of debts you left behind or the people that you want to leave your assets to, you might want to try to avoid probate. And for people who do want to avoid probate, a trust is one way to do so. It's not the only way by any means, but it's probably the most popular among estate planners because it's a good way to address pretty much the complete picture of how your assets should be given out at your death, especially when it's paired with the other documents that come in a typical estate planning package. There are reasons why it might not be for everyone's situation, but for many people, it's actually a great tool for avoiding probate. But that's also not the only purpose of a trust. A trust can also be used as a way to hold assets for someone's benefit while also putting restrictions on what the person can do with those assets. So for example, when, let's say, parents of young children are creating a trust as part of their estate plan, oftentimes it's a good idea to set it up so that if the parents both die before the kids reach a certain age of maturity, the kids get their parents' stuff not outright, but in trust. This means a trust might be set up for each child that's called an FBO trust, which stands for benefit of, meaning for the benefit of the child. Some parents want to do this even for certain adult children. They might do this because the adult child doesn't know how to handle his or her finances properly and so would spend it all in one place. Or maybe he or she has a drug or alcohol addiction. Or maybe the parents want to keep those assets from being reached in the event the adult child gets divorced or has to pay a large sum as a result of a major lawsuit, concerns like that. In another type of situation, let's say you want to make sure funds are set aside for your kid's education. You can set up a trust that says that the assets can only be used for a specific purpose. such as education. In doing so, you can make sure that the person or people overseeing the trust only allow spending out of the trust to be made for the child's education, not for anything else like fancy sports cars or expensive shopping sprees. Also, there are trusts called supplemental needs trusts, also sometimes called special needs trusts. Supplemental needs trusts are usually set up for someone who might have access to some assets, but who might also have a need for public assistance programs, namely for people with disabilities. For example, parents with kids who have special needs will often set up a supplemental needs trust so their kids, when they're adults, can have access to the comforts any parent wants to give their kid while still keeping them eligible to receive disability benefits. Okay, so that's what a trust generally is and what it's used for. Now let's dig in a little bit deeper into creating a revocable trust to see what happens when you go through that process. So for starters, a revocable trust is usually what's used when someone creates a trust for estate planning purposes. When you're making a trust as part of your estate plan, you can make it revocable or irrevocable. That basically just means whether or not you can undo the entire trust. A revocable trust means that after you create it, if you want to change the terms of the trust, you can do it absolutely freely. And if you want to rip it to shreds entirely and make it so that there's no more trust at all, you can do that too. It's very flexible. Most people create a revocable trust so that they can keep maximum control and flexibility of their assets while they're alive, but still avoid probate. I alluded to this earlier, but like a corporation, it starts with a document, and in this case, it's a trust document, often called a declaration of trust. The document needs to specify certain things in order to qualify as a complete trust document, and it can specify much more. Let's first go over what it must specify. So it may sound obvious, but it needs to state what you're intending to do by executing the document. Namely, that you're intending to create a trust with it. Usually in the first paragraph, it'll say your name and that you're creating the something something trust. Fill in the name according to how you want to title it. If you're creating the trust as part of your estate plan, you might just want to name it after you. For example, the John Doe Revocable Trust. Or if you're married and creating a joint trust with your spouse, it might be the Jane and John Doe Revocable Trust or the Doe Family Revocable Trust. Aside from the name, when you create a revocable trust, you need to name people to stand in 3 different roles for the trust. Those are the grantor, sometimes called the settlor, the trustee, and the beneficiary. The grantor is the person putting assets into the trust. You can think of it as the owner of the trust. The trustee is the person who manages the trust. This is the person who makes decisions about investment of the assets, as well as whether or how much to spend and pay out to certain people. And the beneficiary is the person who benefits from the trust. This means that this person can be paid money out of the trust. So basically, the grantor puts money into the trust and the beneficiary gets money out of the trust. And the trustee is the person in the middle overseeing everything. So right now, if you don't have a trust, all of your assets are in your name. That means that if you were to pass away, they would go through probate. To use a metaphor, we can say that your assets are in your pocket. When you create a trust, you're taking them out of your pocket and putting them into a box in front of you. We'll say that box has a lock with a key. So when your assets are in your pocket, we can say that you stand in the place of all of these trust roles, as we call them. You're like the grantor because you own the assets. You're like the trustee because you manage them. If you buy or sell real estate, you sign off on the transactions. The same thing with depositing or withdrawing money into or out of your bank accounts. You decide how much of your money to spend or invest. And like the beneficiary, you benefit from your money because it supports your living and your lifestyle. When you initially create a revocable trust, usually none of that changes right off the bat. That's because you name yourself the grantor since you're putting your assets into the box. You name yourself the trustee so you can continue controlling your assets, so you still hold on to the key to the box. And you name yourself the beneficiary so you can continue benefiting from it. In other words, you can continue spending it however you want. You get to receive assets out of the box. So if you own your home, when you create a trust, you would change title of the home so that it no longer says it's owned by John Doe, but rather by John Doe as trustee of the John Doe Revocable Trust. But other than that title change, you can do everything with the house that you previously could. You can renovate it, you can tear it down and rebuild it from the ground up, or you can sell it and buy a boat. The point is, on a day-to-day basis, you can do the same things with all of your stuff that you could before you created your revocable trust. Got it so far? Okay, good, because now we'll add another layer of complexity. When you create a revocable trust, you also want to name successor trustees and successor beneficiaries. These are the people that you want to stand in line to take over that position at a certain point in time. Let's start with the successor trustee. You name your successor trustee to take over managing the trust for you when you're no longer able to do so yourself. either because you're incapacitated, like in a coma, or if you have a big impairment by something like dementia, or because you've passed away. You're able to specify exactly the circumstances for your successor trustee or successor trustees to take over, but many people set up their trust so that if they're still alive, but let's say in the hospital, the successor trustee can take over managing the trust assets right away. Because you never know what's going to happen in your successor trustee's life, you also want to set up multiple successor trustees so that if your number one choice isn't in place to be able to manage your trust assets, someone else can take over instead. And before I move on from successor trustees, I have to make this crucial point. In any case, make sure that whoever is listed as a successor trustee is the right kind of person to choose. First and foremost, they need to be trustworthy. You are handing over the keys to your kingdom to this person at some point, so if you have any suspicion that he or she might steal any amount of money from you, you should not name that person. There's a way to ensure that they get paid for their time as a trustee, but that's different than the trustee just reaching in and taking over whatever they want. Second, you want to make sure this person can handle the responsibilities involved because it can be quite a burden. This should be the type of person who generally pays their own bills on time, is an upstanding citizen, and is generally stable, mentally, financially, and socially. And you want the person to have the maturity and energy to handle what needs to be done in order to manage your assets. So that's the successor trustee. The successor beneficiary, or successor beneficiaries, are people who you want to receive your assets after you pass away. Since you're no longer around to benefit from your assets, by naming successor beneficiaries, you're able to get around the probate process so the successor trustee can distribute to the successor beneficiaries without having to go to probate court. So once you have all of these trust roles figured out, you know who you want to take over managing the trust, and you know who you want to give your assets to after you pass away, and you know how much you want to give to each person. Then you execute the declaration of trust. In most states, this has to be done in front of a notary. In others, maybe in front of 2 witnesses. And if you're unsure about which you need, you can always sign it in front of a notary and 2 witnesses to cover your bases. But even after you sign the document, you still need to fund the trust. This means making sure that whatever property you want to be part of the trust is actually moved into the trust. Because remember, when the assets are in your pocket, they're still subject to probate court, even if you've otherwise created a trust. It's only after you've transferred your assets into your trust, into the metaphorical box, that they'll be able to avoid going through probate. With real property, that means executing and then recording a grant deed for your property, transferring it from you to yourself as trustee of your trust. This also means going to the bank and transferring every account into the trust as well. Now, note that there are some assets that don't go into a trust. These are things like retirement accounts and life insurance, or accounts on some stock platforms like, let's say, Webull, for example, where you just go to the account and name the individual beneficiaries, or you name your trust as a beneficiary on the account. It really depends on your circumstances what you do there exactly, but generally speaking, you have some flexibility as to the naming of your beneficiaries. But while we mentioned Webull, if you've been thinking about trying out the platform but haven't yet, if you click the link in the description down below, you can get 1 free stock just for opening the account. And if you deposit $100 into that same account, you can get 1 or 2 additional free stocks, depending on what the promotion is at the time you see this video. This is not financial advice, of course, just putting it out there if there's an interest. And just a heads up, the link is an affiliate link. So if you do use it, Legal Bytes will get compensated in some way. So it's a way you can support our channel if you like our stuff. Anyway, I hope you enjoyed this video, and if you did, we'd love it if you could give this video a like. It does help us with the YouTube algorithm gods. Yes! And if you haven't already, consider subscribing to the channel. We upload videos every week talking about the law, and our goal is to educate and inform the masses, and bite-sized and easy to digest pieces. Anyway, see you in the next video.